Yeah. Already.
Okay, well, let's get started. We now have a quorum, and so we'll call the meeting to order. Are there any other matters not listed on the agenda? I think that is a no. I hope everybody's had a chance to review the brief minutes from last meeting, and if so, I would ask for a motion to approve the minutes as presented. So, second. All in favor? Motion carries. All right, well, let's hear about our two proposals, please.
Thank you. Okay, so the first proposal is a single parcel, 175 acres, just south of the intersection between Route 29 and Plank Road, crossroads there. This proposal would eliminate 10 potential dwellings, and the property contains a number of significant conservation values, including shared boundary with existing easements, 49 acres of critical slopes, much of which is in a mountain protection area, and almost all of that forest you can see is part of a high quality ecological core identified by DCR. The proposal to protect these values looks like this. There would be no subdivisions. There are two dwellings currently on the property. One, a 1,400 square foot dwelling, currently being expanded to 2,200 square feet. The second is a 1,400 square foot dwelling. You can see the size limits there that are proposed, and both dwellings are currently in the yellow rectangle there, the building envelope, and their replacements would have to remain in that envelope if they are replaced. Otherwise, it's fairly standard terms, impervious footprint of 0.5%, and a forest protection area essentially covering the eastern half of the property, everything east of the stream, where there would be no timbering, no clearing for agriculture. The forest would remain. So staff recommends acceptance, and I'm happy to take any questions.
9 by Plank Road protection. So that area is grown a lot.
Crossroads with the store.
Just south of the store.
Just south of Dr. Ho's Pizza. Yeah.
Is it in the rural area, future land use?
Yes. Yeah. All of this area is rural area.
Mr. Kirk, you know who the principal at Crossroads Farm LLC is?
The owner of this property, they've just purchased it. They're relocating from Florida.
Former. Yeah. That's why I was.
I see.
And that's the total acreage they own, is that correct?
Yes. Yeah, as far as I know.
And they just purchased?
Last year, I think.
I told you. That's fine. Sunglassed up and see Park, but on the map, what's the stripe area?
That's the forest protection area.
All of that is.
Mm-hmm.
Okay.
Yeah. Yeah, the new owners, I met with them last week and walked the property. They intend to set up a goat farming operation for butter and milk, I think. They have goats currently down in Florida. They're relocating here, expanding.
Pretty straightforward easement. Any further discussion?
I'm just looking at the terms also. I'm looking at the program. Planting of trees with prior written approval of grantee. That's in the force. So is there any in that forest protection area,
Mhm.
they'll have to have a forest management plan. Is that what we would use to determine if we give approval?
So approval of grantee is for some very specific types of timbering, not for all timbering. Generally speaking, there is no commercial timbering allowed. I'm seeing approval of this body would be required if they want to cut to create wildlife areas, if they want to manage the forest, and then we would, nothing in here says that they would need a forest management plan for that. I think that would be one thing we would tell them would help their case. But I think this is something that we started using in the last few years, so we haven't seen this in practice yet.
I mean, I love the idea of the forest, or the fact that that's listed as a core forest area, and if it's got a forest protection area. I also just want to be careful, like if the easement words actually say no, like you just said, no commercial timber harvest, that's potentially problematic if they actually want to do an intervention that might yield a timber stand improvement, for example, that was going to have an ecological benefit, and then they can't actually sell those trees to do that.
I think that's provided for.
Right.
This monoculture of pablo.
If I'm remembering when we've done these before, it doesn't say no commercial timber harvest in those words. It just says no timbering except for these purposes. And those purposes are, we hope, sufficiently limited to preclude kind of just going in and cutting the trees to make money.
Is this the forest core language that you borrowed from us?
Yes.
Is that good language? Do you like that language, Sherry?
Yeah, the state forester doesn't like it much, but
Okay. But it's VOF's forest core language.
Yes. Yeah.
Mitigation projects where there had to be no timbering in the forest core.
Okay.
To mitigate for the pipelines that were cutting through forest. So we sort of dealt with that no commercial timbering problem.
Yeah, that's great. That's kind of what I was asking.
Okay.
Like how nuanced and tailored is that language? Because it's really hard to write good, forest language that is actually workable.
Yeah.
And I know the OF's thought about it a bunch.
Yeah. This is copy and pasted from VOF.
There's no further discussion. Does anybody want to make a motion?
I move for approval.
All in favor?
Hi.
Carries. Thank you.
It's a great project. That'd be a great project.
Good one.
Yeah.
Thanks for helping me, James.
Of course.
Okay. Under the Burgess property.
Yes. So the second, gosh, you can't see that map very well at all. I'm sorry. I'll try to talk you through it. We are discussing the small red property here. The green is currently in conservation easement. This is Biscuit Run Park. So we're just south of Charlottesville on Route 20 South. This is Route 20 here that it's fronting on. This is the current entrance to Biscuit Run. The proposal would eliminate approximately 6 to 8 potential dwellings. It consists of 3 parcels for just under 25 acres. And you'll see at the bottom highlighted there, one of this body's standards is for parcels or for properties under 40 acres. Only 1 dwelling should be permitted, or no new dwellings if 2 already exist. In this case, 1 dwelling exists and the landowners would like to keep the right to build an additional second dwelling. And we'll come back to that. We can talk more about that. The conservation values include another ecological core in the northwest. That patch of forest connects to the large patch that's in Biscuit Run, determined to be very high quality by DCR. It fronts onto an entrance corridor and a Virginia byway, which are two separate ways of saying important scenic road, and shares a lot of boundary with existing conservation easements and a bit of boundary with Biscuit Run Park itself. The proposal is for no subdivisions. The owners are willing to combine the 3 parcels into one when the easement is donated. There is 1 dwelling currently on the property. You can see there that would be allowed to expand up to 3,000 square feet, and the owners would like to be able to build an accessory unit up to 1,500 square feet. Both of those would be restricted to the purple building envelope in the center of the property. Farm buildings would be limited to 2,500 square feet. There's a 200-foot setback proposed there in yellow, where no structures over 500 square feet would be permitted. The impervious footprint would be 1%, which is 10,700 square feet. And they're already fairly close to that. They're, by my approximation, about 9,000 square feet currently. And the final thing would be another forest protection area. And this one, I don't think we've said it's either a forest protection area per VOF's core forest language, or defining the riparian buffer and using our existing riparian buffer language to cover that blue portion and protect the forest, with exceptions for the maintenance of the dam that currently exists on the pond. And because of the 2 dwellings that they're asking for, it doesn't meet the authority's acceptance criteria, so staff is recommending denial. Happy to take any questions on that or any other aspect of the proposal.
I think that the building area, what did you say?
Building envelope.
Can you go back to the first map, please?
This one?
I know the one of the whole area, I think the yellow. So that's the conservation, that's the ease land. in that area.
What's the bit that it's tucked into, the property?
So this here,
I'm trying to figure out exactly what this is.
Biscuit Run is to the west and north, this large area. This one is a VOF easement, but I'm afraid I don't know. I could find quickly. I can.
It's the one that,
I think there's a.
what's his name, kid who used to work with Jaffrey.
Wow.
Yeah.
I can find it here.
Maybe the big one is Jimmy Murray.
No, he's further south. That's
It's currently owned by Edwin and Jean Mikiewicz. I don't know if those names mean anything to you. Now let's see.
Ooh.
It's held by VOF.
Oh,
Where is the entrance to Biscuit Run off of 20?
north,
Up.
west, north.
Up
Yeah,
in there?
Yeah.
up in there. If it had the question about the staff recommendation of do not approve because of the policy, if they built that guest house over the summer and then came back to us in the winter, would it be consistent with policy?
It would then meet the guidelines. But that is your guidelines.
I just wanted to
Yeah.
clarify that. It's, that would be,
Mhm.
you're not on those guidelines.
No,
So it looks like there are 3 rooftops. Is one of those like a outbuilding or something?
two of them are outbuildings. One, I think, is an equipment shed. One's just a basic shed.
And if your numbers are correct, there's approximately 9,000 square feet of impervious surface on the property at the moment.
Mhm.
And they wanted to add, let's round up to 1,000 feet of impervious surface. And they wouldn't really have enough impervious surface, just barely we have enough impervious surface to expand the existing house and build
Mhm.
accessory dwelling unit.
If they wanted to do both, they would have to remove one of the old, at least one of the old.
It's really squeaking by
Mhm.
on the impervious surface. The
So
overall.
They also have a swimming pool, which is adding to
Yeah, what's
Does the
there?
water get impervious surface?
the water. Yes,
Pool, I think.
if the water is being held there in a concrete tub, that is impervious.
So what's there to create 9,000 square feet of existing space? You got the
Um,
pool,
The house, the pool, the house is a fairly, even though it's 2,100 square feet, it's 1 story, so it's fairly large, creates a large footprint. The pool, the equipment shed, the shed, and a small garage-like structure. I haven't visited this property, so I can't
is
say
it?
for sure. Yes,
Why is there a gap between the yellow setback and the pink building area?
200 feet.
we
200 feet is actually not a useful distance, frankly.
you could propose expanding it. I think this first came to us 18 months ago,
Yeah.
before this body was requiring building envelopes, and so the building envelope was a later addition.
Does the building envelope setback, the building envelope only applies to residential structures or residential and accessories residential too, but ag structures can be anywhere as long as they're not in the.
In recent deeds, I think I'm right in saying building envelopes aren't mentioned in our current deed template because it's from 2019. In recent deeds, when there have been building envelopes, we've limited it only to dwellings, not to anything
So
else.
Sherry's question would be move the setback all the way up,
Mhm.
make it like 500 feet.
Mhm.
So if it's only for residences, you could have an enormous indoor array or something if he had the square footage, which he doesn't.
Which he does, but right.
But yeah, because I'm just used to thinking of building it, because being anything,
Mhm.
you know, over 500 square feet, but that's not the way it is here.
No, it can be if you want it to be.
Deviate from the policy.
So there's like
What are
3
policies
skinny
for?
parcels that add up to about.
Sorry, I'm struggling to follow both conversations.
Called code talk.
I can't do co-listening.
Skinny parcels, they add up to about 24 acres.
Yes.
So what are they approximately, 8 each or something, or,
Yeah, I think it's
and how do you? get
9, and
6 to 8
6 or
position
something.
potential dwelling?
That's a very good question. So I have it here that going from south to north, 9.6 acres with 4 development rights, 9.1 acres, 4 development rights, 6 acres, 3 development rights. So that is 11 theoretical development rights in total. I don't think all of those are usable.
Right.
I think 8 to 10 of them are usable, given the critical slopes and the
What about road frontage or access or?
that can always be, or that can usually be accommodated with a clever subdivision and
So these
a
parcels of
developer.
record go all the way back.
Mhm.
But there's still, I mean, it got cut up from something larger, because there's C2, C3, and C4.
all the way back to 54, I think. I found a plat and they're like this.
So I think that's a mitigating factor as well, because the size of the property, number of development sites that would warrant deviation from.
You threw it up pretty royally, given what there is.
If the right person can.
And it's right on 20.
I just think that if we're gonna deviate from policy, there ought to be a pretty compelling reason. I think the number of potential development parcels on this relative to the size perhaps warrants that.
I
Well,
like the
and it
pond.
looks like the total residential square feet that he wants is 4,500.
Which is
Where
crazy.
you would normally see a
Which isn't crazy.
principal family dwelling at 4,500. So as long as it's all in the pink space, I'm not sure how much harm it does.
So does that water run, this could run into that little pond? Or this could runs up here? I'm just
Yeah,
wondering about the connection.
This stream eventually flows into Biscuit Run, if I remember correctly. Is that right?
Looks like it, yep.
So there's a spring very close to this, probably just to the south of this property.
Can you go back to the other
Yeah.
image, um,
The bad one.
yeah.
It's over this.
Who's the lawyer? Lee?
No, this one, they're currently represented by Todd Hochrein of, I don't think
He's a broker.
He's a
He's not a-
Right. right, he's not an attorney, but he's represented them, taken them through the process up till now.
They don't, so presumably.
Still on the projects.
Not that I know of.
It would be nice if there were a proper lawyer involved.
Shall I let them know?
I think optically, taking an easement on 25 acres is challenging unless there's a compelling case to do so. I do think the elimination of building rights in an area that's close to town and has seen significant growth pressure is a worthy endeavor. I think we would need to articulate that strongly to the extent we can, should we take this easement.
Well, am I wrong? But I always thought we soft we like that extinction of the rights, but
Mhm.
that can't be core. to These conservation. I mean, yeah, we like that. In fact, it always comes.
Mhm. I think it's one
You
of
gotta
the
go
main.
through all the other checks.
Yeah, you do. There has to be other
Yeah.
things of value to protect. But extinguishing development rights is one of the core
Well,
goals of the easement program.
can't be I don't. know.
No.
In this
You
area,
get it.
it's certainly significant, I think,
Well,
given where it
Adjacency
is.
to a state
It's got
park.
conservation on one side and a major Constitution highway or some such thing on the,
On germ through hollow ground, probably.
nah, that's gotta be on 15.
It's just
So you don't have a deed of easement?
Sorry.
You don't have a deed written drafted?
No.
Right. Hmm.
We rarely do at this stage.
Yeah, this is just south of that property owned by Forest Marshall.
That's what I'm thinking, yeah.
It
yeah.
is.
Yeah.
This was on the market a while back. Tim Michelle tried to get me to buy it. When it first
It
came.
may have been the fellow who helped me when there was a snake in my car, which occurred right near Forest Marshall's.
Well, there you go. That's the, what's the name of that farm? It's got a farm sign. Everybody's seen it. This is just south of that. Argyle.
Oh, aren't
Yeah, yeah,
That's
Argyle was Forest Marshall's. And maybe
Yeah.
it's.
Yes, this is the next property immediately south of Argyle Farm.
Yeah.
Oh. I didn't know. Okay.
On the same side.
Rural landscape from along 20. 200 feet is totally insufficient. If they move the yellow back to the pink, I don't think it's a big problem.
And I think that I would be in favor of this, even though it deviates from the policy because of the significant number of potential development rights relative to the parcel size.
Yeah, I mean, I sort of started with that.
Yeah.
Even that, and the fact that the square footage of the dwellings in the aggregate is small. However, I think there needs to be an actual lawyer in this deal, not just a tax credit broker who's going to benefit by the sale of tax credits. So that, in particular, you all need to look at the 8283 form when it comes through and make sure that you think it's viable, counselor.
So James,
Yeah.
if you do expand that to the purple area, how many feet do you pick up? You think? Guesstimate.
I would guess make that 400 feet instead of 200. It's 200 now. That looks roughly double.
Yeah, it looks like.
Oh, I see. Oh, even more.
440, 450, something like that. We looked at these distances a lot, right?
Well, I also, as we all know, there are different opinions on the value of increased easement land in this county. I think to the extent that we increase the conservation values of this by what Sherry's suggesting is perhaps not only good in and of itself, but it's also good that will be more restrictive as a public body.
Mhm.
Does anybody want to make a motion?
I'll make that amended motion. Should the yellow 200 feet go back 200 and approximately 40 feet to meet pink, I would recommend approval. Provided that there is some lawyer involved
Can we make that?
Yes.
in the drafting and that the 8283 form be reviewed.
It will be.
That I would want to make that a condition of approval simply because
No.
that's not been a standard. Do you have a correspondence that you generally have with landowners that advises them that they should seek counsel? Is that a standard part of our communication?
We
And I would share your concern about making that a condition of approval.
Yeah, okay, well, that's fine. I just think that, and I think I've said this in general in the past, that I think we need really to require that people have some representation. You know, especially when we were doing like ACE easements and there was a lot of money involved.
mhm.
People do foolish things.
Yes.
I don't know about, again, I would maybe just bulk with the word required. But
Yeah,
also encourage.
right.
Yeah.
I have said before that it is strongly encouraged. It's not a standard thing, and I haven't done an easement to the end, seen it through to the end, where someone hasn't had.
At some point.
Right. And if someone were going to do that, I'd want to make very sure that they knew what they were doing and knew that we encouraged them.
Is going to encourage their client to have a lawyer.
We've worked.
It would be nice to know that that was the case.
We've worked with this broker once before, 2 years ago, and he did engage a lawyer after this stage.
So let's see, we have a motion on
We
the
have-
floor. Do we have a second?
With the, I think her motion included and require an attorney, I would say, and just encourage an attorney, encourage the lender to be represented by counsel. And I would second that.
Ms. Butcher, have you agreed to that amendment of your original motion? Okay.
Okay, so we have a second. Further discussion?
Yeah.
Yeah.
So-
Yeah.
Out of fact,
Robert's rule. No, but staff suggests this be denied.
Mhm. Just because it doesn't meet your criteria.
Need to follow our policy.
We're always very careful not to make decisions or suggest decisions. And we try as much as possible to follow the guidelines that you've given us in making recommendations.
Okay, so what were the explicit reasons we were outside our guidelines?
The guideline is for a property smaller than 40 acres, there should be only one dwelling permitted.
Go back to his comment, if they do all this before coming to us, they,
If they built a house, so
Then-
under the existing guidelines, if they built a house this summer and came back to us in the winter, then it would be with a new proposal,
Yeah.
they would be in compliance with our policy.
Is that right, that if there are two existing on 24 acres, that actually meets the guidelines?
The guideline says in that case, there should be no new dwellings permitted, but
Yeah.
otherwise it's fine.
Yeah.
If I agree with your concerns that the guidelines are not watertight and often we're left without much guidance.
Well, I think
But-
this is perfect. You are recommending that we follow the guidelines, that it's in compliant, and I can. At least at the moment, we have a motion on the table that deviates from those guidelines with a reason.
Mhm.
Because of the
Yep.
higher number of development rights that we see on this relative to the total size.
So just to add, I think the amount of acreage, there has to be context. So if you take an area that's heavily eased and there's 25-acre parcel that comes up for conservation easement that eliminates development rights, that can have a profound effect on the whole area. So I don't think you can just look at acreage size in a vacuum. I think you have to look at it within the context of other conservation easements in the area and the pressure on growth going forward.
Mhm.
Again, in Keswick, a 25-acre parcel that gets developed would have a profound effect on all the other
I
easements.
mean, think
So-
about Ev Droz's property,
Yeah, so
30 acres in the middle of a lot of, surrounded by 1,000 acres of East Belmont. That 30 acres gets broken up and
it's big issue.
it impacts the whole area. And I feel like this could be
To your,
equal harm,
Mhm.
could not equal, but harm could happen here and on this road, it would be too bad.
If it matters to you that the staff recommendation makes more sense or is more rational or more consistent, we could put it as an agenda item on a future meeting to,
no.
tidy up, but if you're happy with it, then we can continue. Mhm.
Why staff.
I like the idea that you came in and said, but you gave us all the information. And then the
Yeah.
reason why it was denied, that was, that helped us make a decision to take all this information in, so.
I think you think it was the right call. Dan.
Yeah. Sure.
All right, so we have a motion, we have a second. No further discussion?
The only thing I'll say further is, I think that easement, that parcel that's under easement across the road. I think that was the very first easement that VOF took in Albemarle County.
That may be, that's what I'm thinking, is it may be Dr. James Andrews.
Yeah. Yeah,
Or
I think
his-
that was the very first one in Albemarle,
And this,
back in the 70s or something.
the easement across the way, I believe, belonged to him and he gave it to his son. And then the son lost it in the divorce.
And just a bit of trivia.
Yeah.
Okay, so it's time for a vote. All in favor?
Aye.
Motion carries, thank you.
James, just one thing to think about on that question I asked about legal counsel. Under
Mhm.
Managers Land Standards and Practices, we recommend that all of these holder convey a notice to landowners at some point in time in the transaction.
Yeah.
That they, various things.
Yeah.
One of which is we recommend that you have legal counsel.
Mhm.
PEC, for example, will actually have a disclosure letter that has a number of things like that in it. That
Yeah.
is disclosing to the landowner, will actually ask the
Mhm.
landowner to sign that disclosure letter prior to entering negotiation.
Yeah.
So that might be something to think about, just to make sure that we've got something in the paper file.
Yeah.
That says
The-
this was.
There's some acknowledging.
Advice that was given to you by the body.
Yeah.
Of certain things that we're not providing tax advice, we think might have.
Mhm.
So I could get you some
Yeah,
examples.
also the VOF has something called a disclosure form.
Yeah.
I
And
think we've already seen it.
Mhm.
Scott and I have drafted one for this body
Good.
that includes both of those things that you mentioned.
It's three
Yeah.
votes.
Yeah, right.
Who have
Sounds
So-
familiar.
That way,
realized this was a good idea and I ain't gonna do it.
Mhm.
and that way, if Sherry ever asks the question again, of do they have legal counsel, you could say, I don't know, but they've signed the
Yeah.
disclosure letter.
Yeah, we have that in a couple of other documents drafted that I'll be working with Gabe on to bring before you, make sure Gabe's happy with it and bring before you for adoption.
Yeah, there's nothing to prevent pernicious or poor legal counsel.
The bar.
Or bar.
I see that the
So, move on to new business.
Yes, but did
Go
you?
ahead.
We have, so I have 3 items of new business tonight. Others may have more. The first item, let me get situated here. The first item is regarding a 2.8 acre parcel in the Bundoran Farm subdivision. I received an inquiry last week from a neighbor of this parcel asking if it would be a candidate for a conservation easement. You can see that it's vacant, it's wooded, it has potential for one dwelling. And I told him that I did not think that it was a good candidate for a conservation easement. It was much smaller than this body typically takes. But as always, when giving that advice, I have to say that it's not my call to make, that ultimately it's the authority's call to make. So I said that I could bring it before you all for a more definitive opinion. For context, the current owner had a permit to drill for water on 2 sites. She drilled one of the sites unsuccessfully, did not drill the second site, and the permit has expired. It's been on the market for a while and she hasn't had any takers. And now the neighbor is asking, could she put it under easement and then it would decrease the value and we could buy it from her and protect it. So what would you like us to tell
How
them?
much land does the neighbor own?
The neighbor is the 2 acre parcel here.
You've probably been getting calls. I've been getting calls as a realtor because people are getting their tax bills and they've come out of land use and they're
Mhm.
trying to find a way, but to have a little over 2 acres, it'll always still be a 2 acre home site. It'll always be taxed appropriately. So
Mhm.
that's not, I don't think it's going to reduce the value. If that's what that angle is, so the
Well,
neighbor can buy it.
It would presumably, correct me if I'm wrong, reduce the market value because most of the market value is kind of tied up in the future dwelling that could be built. And if there's no future dwelling, then there's a lot less reason to buy it.
I think there's any chance in the world that we would take a 1 acre unless it was leveraged to get 300 acres next door. So, yeah.
Access to the Yancey property behind, no, not even that, it doesn't.
No.
give access to any- No, I think the answer on that is no,
No.
like, unless she wants to give it to us in fee. And we make it a public park, I'm doing farm. Go recreate.
Yeah,
There's no public value associated.
I'd go over well.
I know.
Okay, thank you.
Does
That
anybody agree with my, no, or Peter's, no, disagree with that?
does anyone disagree?
And she
Okay.
could go to the county assessor and get the thing declared unbuildable and reduce the assessment, but it's really not something for us.
No, that's not our concern. Okay, thank you. The second order of new business, sorry,
Pursue it.
to nothing. With-
Removal of the lot line.
Would that be a self-taking?
I did.
Really?
It's one of the few that's ever been pursued.
So the second order of new business is regarding the Ragged Branch property. This is the preservation tract where the Ragged Branch distillery is. We recently had a homestay application on this parcel. And we were recently notified by Virginia ABC that they have applied for a Class 2 farm winery license. That is a license to be a farm winery, and all that entails. So manufacture wine, take in wine, ship out wine, sell wine on the premises. And specifically Class 2, there are 4 classes of farm winery license. They determine how much wine can be made, how many acres have to be in grapes, and also how much of the produce has to be from the property itself. For Class 2, at least 51% of the products to manufacture wine must be grown or produced on the property. Class 1 license requires all the products to be grown or produced on the property. And this is fairly standard practice. I think that Virginia ABC lets the locality know when a license has been applied for. We are planning to send a letter to the landowners reminding them of the relevant terms of the easement. We think they can still do activity under a Class 2 license that would be within the terms of the easement, but there's a lot that they could do with a Class 2 license that would not be under the terms of the easement, that would be in violation. Such as processing agricultural products that have not been grown on site, bringing in
Larger scale agricultural processing.
Is not permitted.
Larger scale agricultural processing is permitted under a Class 2 winery, but would not be permitted under the conservation easement.
Because
It's just a term of the easement.
What about like tasting rooms and restaurants and weddings and all that kind of hoo-ha?
So this license, I believe I'm correct in saying this license does not affect events and the ability to do events. That would be a separate license. It does allow for something like a small tasting room, I think. It allows for the selling of wine on site for either on-site or off-site consumption. And so our plan is to send that letter to the landowners, and we just wanted to bring that to you in case you had comments or concerns with that.
Should it just be continuous on the agenda? Continuation of more of the same.
no, it's always something different with it.
It's a new problem with an old property.
That's right.
But I don't think we can prohibit anybody from applying for whatever they want to apply for.
No.
It's my belief, this is really kind of an interesting legal question. I believe that they, things like this last year, it was probably 10 years ago, you remember, the state said that if you're a winery or a vineyard and you have a certain amount of acreage in grapes or apples or whatever it is, that events are by definition agricultural. And again, this is from memory, which is never safe for me. But my belief is that basically gave way to all of these East properties that are now effectively event factories. And so if that's the case, we can't prohibit them from applying for this license. And it may well be that license trumps some of the terms of the easement. I don't know the answer to that.
I don't think the latter. I mean, I think the real question is what's the most effective channel of communication. I mean, I think that staff's determined that it would be a good idea to remind them of the terms of the easement now that they're applying for an expanded use. Then the question is to whether to lodge a formal objection with the ABC or simply to write the property owner. And it's staff's recommendation that we go with the latter, just write the property owner rather than lodging a formal objection with the ABC.
Because there are some activities that they could you under that class 2 license that would be permissible.
Correct. There's not an exact
Mhm.
correlation between the terms of the easement and the class 2 license, that there is a sort of in the Venn diagram, there is an overlap where they could be compliant with a class 2 winery and be compliant with the easement at the same time.
Why did they apply as a class 2 rather than class 1? And class
We don't
1
know.
stuff would be allowed under the easement, right?
Because of all the grapes.
51% versus 100%
That's why.
produced on site.
It's, yeah, so it'd be another, because they're presumably expecting.
Gonna
to
bring in
import some
their grapes off site. So Andy, you mentioned large. Is there a differential? Like, is there small that would fall under the easement? You called it large.
So the easement allows for de minimis commercial use and limits it to de minimis commercial use of the property. And that's been defining what constitutes de minimis on this property has been a long running issue.
So you're
That's
processing,
commercial recreation. Is what's limited, not commercial use across the board, is it? Is it as commercial recreation?
I don't have the,
Usually you see commercial, the other was commercial recreational, it's because of section 1031C, I think.
Tim Lindstrom's problem.
so you're saying that if they just produce
No, we don't.
wine using the 51 acres or the 51% produced on the property, that would be okay. But if they bring in 49% from another property, then it's considered.
I'm not sure that we've defined, I'm not sure we've really set the contour on that.
The reason why I picked up on your word large, that you kept referring to it as large, and I thought, well, maybe small is okay, but large is not.
There's a question of what is an accessory use as well, whether it is accessory to agriculture.
So
So the letter.
where does the water?
I don't know.
1%. So how do we police something? Because yeah, we got that problem with the other activities going on at this property. I've been there.
It's
twice.
a good question.
And
The terms of the easement allow entry on the property with reasonable notice to the property owner.
I mean, if you open the door that they can import 49% of material to make wine, that's get pretty big. Now, does that mean they have to match it? In other words, they have, if they have the yield of say 48 acres.
This is 92 acres.
So let's say they put 20 of it in. That they can go get 20-acre nominal yield and bring it in and process it. Is that
I doubt it's measured by acreage, but by weight or something. Yeah.
Yeah.
Yes.
yeah, by weight, but they're just saying they could bring that in external now.
But if the language really says de minimis commercial activity, not commercial recreational activity, then importing half the grapes, this is not it. I mean, it has all the makings of a violation already.
So we're back to this
Yes.
word I really like. The minimis. Sounds like you should know what it means. It rolls off the tongue. The minimis.
I mean,
But what is it? I mean, like, okay, is it 1%, 5%?
Itsy bitsy, teeny weeny.
So I just think, I know what you, sending them a letter and saying, watch out.
Mhm.
yeah,
Yeah.
if they're not in a position where they're doing it. they're just
Right.
applying for.
But watch out.
Yeah.
Because, and we should say watch out, because.
Can you send a copy of the letter to the ABC?
That's what I was wondering.
Right,
Right.
right.
CC.
Can you decide?
Not really. I mean, the way that the ABC process is set up, they allow for formal objection. And if you file a formal objection, you should expect to have a hearing.
Mhm.
And our past experience with the ABC is that they really just look strictly at sort of the peace and good order of the locality rather than considering land use implications.
So your plan is to send a letter and you're looking to this body for the sanctity for that effort.
We wanted to give you an opportunity to voice concerns or questions.
Let me ask you another question. Let's say they apply for that and they get it.
Which they will.
Then what?
Then I think
How do you
as
tell them about it? If they can apply for it, this group will apply for it. And if they get it, they get it.
Mhm.
Now what?
I think as the stewardship manager for this property, I would be checking their website. They're a public business, checking what are they advertising, what are they selling, what are they producing. You know, you raise a good question. I wish we would talk more about how do we enforce certain terms. And I think in this case, we would have to rely on, we can't go in and count the grapes, how many are coming in and how many are grown. But I think we can look at what their business is and what are they doing with the property.
How are they doing with the distillery?
Good question.
We don't know.
No.
When you
Everything's like a rock and hard place. I mean, we really can't deny them going out and getting, but we're setting ourselves up for acceptance to
Well, and I think that's the motivation behind sending a letter at all, is just to put them on notice of, we still have this, the deed restrictions, and just a reminder, here's the deed restrictions. We see you're applying for a license, that's fine, but keep in mind what the contours of your existing easement are. So I think it's designed to address your concern.
I think it's the right move to send the letter. You said, James, you wish we would talk more about how to enforce certain terms.
Mhm.
You want to unpack that statement?
Just generally speaking, when we take, I think both in the template we have now, some of the terms having gone out into the field and tried to enforce them, they're hard to enforce, especially given we can't enter buildings. When we try to regulate structures based on their use, especially whether or not they're residential use or not, it gets difficult. And of course, it's hard for easements like this that have old language, where we all realize that the language isn't good enough to be kind of strongly enforced.
Do you customarily now get, if they apply for a building permit,
Mhm.
will it automatically come to you all?
Yes.
So you can look at it. I mean, the next question's gotta be, how many square feet is more than de minimis?
Mhm.
So it sounds like you're saying two things. A, look at, like, have a critical conversation about the language that we're currently using in our easements.
Yes.
Future stewardship and leadership for those, and also helping you have more guidance about how to effectively steward existing easements that we hold. And I do think that, like, we should put that on an agenda
Mhm.
and have conversations like that to make sure that our staff
Mhm.
have the direction and guidance, and that we've thought more critically about our easement terms to make sure that we're having a set of easement terms that are robust, so that we're not just responding to everything that comes in over the transom, but that we're also helping give you some parameters to improve the workflow going
Mhm.
forward, especially when I hear you make a comment like that.
Yeah.
And-
Yeah, no, absolutely.
to
It
help-
seems
to help
like
you
the next
comfort.
inevitable thing is they're gonna apply for, let's just say, 2,500, 3,000 square feet of processing, which is clearly not de minimis. So what do we do then?
We will bring it to you at a future meeting and ask you that question.
But it's
That's also like I'm saying, maybe we even like this could be for as a proactive way.
Mhm.
Come with that language that is in this easement,
Mhm.
and begin to think about what we might do, what that means.
Mhm.
Like, we will have what is our existing language template.
And just to clear up the prior discussion, the restriction on the deed is for de minimis commercial recreational use, as you suggested. But there is a term saying the processing of agricultural products is not an agricultural use except as an accessory use. So I was off on the language, but right on the concept that accessory agricultural processing is allowed, but non-accessory agricultural processing is not allowed. So there is still the same concept of you can have some agricultural processing, but not a large amount.
And that's a deviation, that agricultural processing, like that's a special, because a lot of agricultural easements, processing for agriculture is automatically included. It's intentionally included as an allowable activity. This easement
Not on this property.
This easement says that it's not intentionally out unless it's accessory.
There's sort of an exception to an exception,
Yeah.
that basically agriculture is allowed, but agricultural processing is not considered agricultural and therefore is not allowed.
Unless it's accessory.
Exactly. And so you've got the exception to the exception, and then it is challenging to delineate what exactly constitutes accessory versus non-accessory. But again, the concept of large versus small agricultural processing.
Well, I think that actually is pretty, it would be interesting to see where that would go if you were sitting in front of the judge, but the accessory activity would be accessory to a permitted agricultural activity on the property, which would be the growing of grapes.
Yeah, it
So I
seems
would
to me
argue
that
that-
what that says is class 1 is permitted, class 2 is
Yeah,
not.
and that would lead me to the same conclusion, that growing of grapes is allowed, growing of apples is allowed. Pressing those apples into apple cider would be permissible, but importing apples from somewhere else is not accessory to agriculture on that property. It's accessory to agriculture somewhere else.
I mean, I don't know if you want to say that, but that seems like that's pretty much what accessory means, is exactly what
Mhm.
Rex is saying. It's accessory to the farming operation that you're doing.
It's accessory to an activity permitted on that property.
And it's not accessory to hauling stuff in from other places.
Right. For example, think about you'd have an agricultural crop that comes from somewhere else that I just don't even grow up property. I just import to the property and process. It's not an accessory activity.
What if it's an ingredient?
Not a. I'm gonna mill spices that I'm gonna make vanilla that I import from Madagascar.
But I think
Is that an
when we
agricultural
dealt
activity?
with this distillery, there was their intent importing things that they weren't going to grow.
Mhm.
Well, let's send a letter.
Okay.
Do you think that we should say, and I am not familiar with the ins and outs of the class 1 and class 2 specs, but
Mhm.
that we should say that processing an agricultural product from the property is permitted. Bringing it in 50% or 51% or whatever it is not permitted.
We'll certainly draw their attention to that clause.
My suggestion would be basically to recite the passage as it exists in the easement, to basically let the language of the easement speak for itself.
Let them interpret it.
Right.
Yeah.
So it's supposed to, yeah.
And that might the word the demolition.
It does for commercial recreational use, but again, as it applies to agricultural processing, the processing of agricultural products is not an agricultural use except as an accessory use.
Yeah, I think that's the more controlling
yeah.
section, really. So
All right, what's your third item?
You know what our third item is? So third item is this rebuild project that Dominion has filed an application for with the SCC. You can see the line here runs from Charlottesville just to the west of Dardentown Park up to Gordonsville in the east. And the Dominion currently has 100-foot utility easements, 100-foot right-of-way along this corridor. And the proposal is to replace, or the project would replace the existing structures on the left, average height 56 feet, with the new structures on the right, average height 116 feet. So not to scale. This was taken from Dominion's presentation. So roughly double in height, but Dominion's saying this would utilize the existing right of way. They're not seeking to acquire new utility easements. As I'm sure you all know, this is one of the most heavily eased corridors in the state. The blue parcels are held under easement by VOF. A large pink one is Nature Conservancy. There's a beige one held by PEC alongside it. The green parcels are held by the county. There are two in question. The first, this square parcel here, that's an ACE easement on Strawberry Hill Farm. That is, I think, unique in the ACE program in that it's co-held by the county, meaning the Board of Supervisors, and VOF. So it is not held by this body because it was acquired from with a VOF grant, I think. But one that is held by this body is the smaller one down here that was donated in 2017. That's the Van Tassel property.
Yes, Kesmont Farm.
Thank you. It's this parcel here. You can see the utility corridor along the western corner there. And
The yellow things, yeah.
Yeah.
Ugly shirt. Okay.
disputing the ugly. So I think the significant issue here is whether or not the project is within the scope of the existing utility easements, because those utility easements predate the conservation easements. And we are reviewing the utility easement for this property and for the Strawberry Hill property to determine if we have any issues in that regard. We met with VOF as co-holders for Strawberry Hill last month, and they're doing the same thing. They have attorneys looking at all of the utility easements across the property. That's the big issue for them as well, judging whether this proposed work could go beyond the scope of those utility easements. So this is just an update for you now.
But if it is within the 100-foot wide existing utility right of way, we don't have any real dog and fight, do we? I mean,
I don't think so.
Yeah.
No.
They're not looking to expand the right.
No, they're not seeking more easements.
It's not across the Lawson property, which is farther north.
Yeah, that's already been rebuilt. That already has the tall structures. It stops just before that.
I'd like to make a couple observations. Obviously, I'm very much involved in the situation and a party to a lawsuit against Dominion. Lawsuit basically questions the right of way and specifically whether they in fact have 100-foot right of way in all these properties is a matter of debate. So what happened, these right of ways were given typically in the late 1920s to support of rural electrification. And in many cases, they were updated to specify 100 feet. They weren't in all cases. So for example, my right of way was never, the width was never specified. And it will be a point of litigation is whether in fact they do have 100-foot right of way. So I don't think that a conservation body can take Dominion's claim that they have a 100-foot right of way in every case with sanctity. The other part of this is I've got a copy of the original easement. This was a purchased easement in 2008, having paid $1,130,000 for the Strawberry Hill easement.
Which is not that.
So not this one.
But the question of, and I haven't looked at the deed on this particular property, but if in fact the 100-foot right of way is in question on some of this line, I think it brings into question whether Dominion has the right to build what in fact they say they want to build. There was a case in 1980 where Dominion sought to increase the scope of the line, and it was taken to the SEC. And Dominion said, well, we really don't have the sufficient right of way for what they had contemplated, which was much less than the towers that they're contemplating. Now that it's Archibald Craig who did that. The other thing I would point to, and again, I don't have all of the information, but there is language in a deed. This goes back to 1963, which limits the pole height on part of Strawberry Hill to 55 feet. So the easement holders, I think, are obligated to take a hard look at these right-of-way deeds, and they're complicated.
We are.
These
Yep.
things go back to
Yeah.
1930. We hired title companies to search all of them
Mhm.
and determine where we stand on this particular case. Are we the authority on the old easements now, or is it ultimately?
For most of them, yes, but for Strawberry Hill, no.
So the Board of Supervisors would have to opine on whatever they want to opine.
Yes.
So,
Yeah.
so wait a minute, let me finish. So the other part of this, the SEC last Thursday issued their timeline on the review. And in a highly unusual instance, they truncated the review process. So in that truncated review process, the public comments are due by July 8th.
Mhm.
And there is a mechanism by which the interested parties can petition for a meeting in the area and a review process. It would likely trigger the normal timeline associated with the review process at the SEC, which would include public comments, it would include expert witnesses, etc. So I think that the immediate decision, perhaps for the Board of Supervisors, is do they want the SEC to take a normal approach to the timeline, or are they okay with this much shortened timeline that has been put forth by the SEC? Dominion had the option of extending the deadline and recommending that the SEC, which they declined. So I think that's the decision. Now, whether you want to go to the Board of Supervisors with this or not, that's a question for you all.
Yeah. And so I agree with what you're saying, that we shouldn't take, I think first point, we shouldn't take Dominion at its words that they have 100-foot right of way. Absolutely. And we're reviewing those utility easements to verify that. And as you say, there is a deadline of July 8th to give comment or to become party to the process. And we will aim to finish that review before July 8th in order to know whether we feel that there needs to be further review, whether we have issues that we want to carry forward to the SEC.
But it'll be the board if the board wishes us to participate, we'll follow the board's direction on that.
I don't think they have another meeting.
The board meets next week. We're to have a meeting.
That would be relative to the Strawberry Hill. We have our own.
We have this easement. Yes.
Well, right, in terms of if we want to be a part to that as well.
Well, again, we'll look to the board in terms of the direction of participating on Strawberry Hill. So,
but this body could decide it wants to participate relative to this Van Tassel property, couldn't it?
conceivably.
Is the county the co-holder on this one?
No.
No.
Singly held by this body.
This was a donated.
So it wasn't an ACES.
No.
No, this was a donated.
Otherwise,
And of which I'm sure one of the so one of the things, the thing I was going to say is, would you as litigants, not, and that's squirrely because you're on this board process in a minute, but is there documentation that you all have unveiled in your title work or in your research that would be helpful to the easement authority that you could share with the county that would be helpful in us looking at?
Well, the lawsuit's about our public record, and I think the the nuances of the specific right of ways are relate to the individual properties. The question though is in aggregate is if part of the line is restricted by a compromised right of way, what bearing does that have on the entire project? So if you're comfortable, telling you this is a heavy lift because we've done. If you're comfortable that you think you can get through all the deeds going back to 1928 and determine to what extent there may be an issue with this right of way, I'm not quite sure how you will communicate that to this body prior to July 8th.
Well, I guess that's what I was wondering is if you all in the process of doing some of your research might have information that you might have already uncovered that you could share with the authority to expedite changes.
I don't know that we have, I don't believe we have the deed language of Kesmon going back. We do have the deed language on a number of properties. They're bank boxes.
Yeah.
Sure. Three of them that wide.
This goes back to the 40s, and it was called Paradise. It was held in 3 different parcels.
Was that part of a bigger farm? Must have been. What's probably part of Castle Hill or tomorrow.
I don't know about that, but in my opinion, it was a rush easement. It came in, it really had 10 division rights. It was approved with 6 division rights. It was, I thought it was kind of botched up, but anyway. I did know it's in 3 parcels, but I do know that it goes back to like 1940. So it could be one of those easements on the back that has some sort of limitations on the 100-foot mobile.
But it's not this property that has the deed limitation from what?
No, that's Strawberry
1956.
Hill. that he said.
That's Strawberry Hill, right?
And again, I don't want to suggest that I don't know exactly where this is on Strawberry Hill, but here's the deed language right here.
The other thought I had is
You're going to have to go back to day one. That was part of Castle Hill, and so that original deed was 19.
that was part of Castle Hill.
Well, it's right next door.
Yeah.
I mean,
Yes,
Castle Hill's right there.
My other thought was, the easement, the body holds it, that just back to this idea of like, is there an involvement authority to comment on the line? We hold an easement, the purpose of which is protecting land in the National Register of Historic District, and doubling tower height will have a negative impact on the very conservation values that our easement is designed to protect on this property.
Yeah, that's a little more the grounds on which we should be commenting if we're commenting at
So,
all. And
yeah.
I don't think we should be, other than to bring up if there is a legal oddity,
Well, unless we have,
to help the county attorney's office find it. Or give
or
them
unless
a
we hold an
copy.
easement that would require an expansion. Again, it goes back to, do they really have 100-foot wide right of way? And what does our easement actually protect, and where are the boundaries of our easement relative to that right of way? That's an important question we need to know the answer to. That's one thing. And then the second is, even if they have 100-foot wide right of way, doubling the height of the towers is going to have a negative impact on the property that we are charging.
Well, exactly. That's what I'm thinking is a more sort of down the middle comment for a conservation group.
Yeah.
Looking at that swath of cleared land, I'll bet that's 100 feet. So they may not have it, but they may be.
But they may have it.
They may have it by having possession.
So that'll be a matter of identification. But I think to Rex's point, there are really a couple venues here. So the SEC in their proceedings, they will take comments from interested parties, and they have to, by statute, look at all aspects of this project, including the impact on historical sites, scenic, historic, byways, whole shooting match. So that would be an opportunity for a conservation group to make comments that saying, we protected this.
That's what I'm suggesting is we would, I would see a logical role for the authority to comment on the project about the the work that we have done to protect land in the National Register Historic District, this property, and the visual impact, again, the
Visual.
expanded.
So what's the
height
average
with
height of
all-
those trees?
Take 60. Little poplars to do.
Yeah.
So that
I'll defer to Mr. Treeman here.
the pole height,
He knows the
so they're
streets.
58 feet currently
Yeah.
on the line. The pole height they proposed, and actually in the SEC filing, you can look at their specific poles and what their height is. So in my case, there is a pole in the front field that's proposed to be 130 feet. So
So different towers in the system will have, so that number of one.
That's an average.
That's not definitive. Some poles might be higher or lower.
Correct.
And that depends on topography, I would guess. That makes sense.
And the further apart they are, the higher.
The higher they are.
By
Exactly.
So can you see them from 22
Yeah.
to 31? If,
Sorry, just goes word. That's what.
So you can't, all I can tell you is that from the road by the Van Tassel property, you can't currently see
Can't see
the
what's
clearing. You can't see what's currently there. I have some images Dominion provided of kind of before and after shots. This is actually the Strawberry Hill property.
Well, so presumably it's right here. So in the current picture, it doesn't break the skyline,
No,
but in the future picture, it does break the skyline right there.
here.
I would, as a nearby landowner, I would take significant issue with the plan. Again, I think the real world thing, you don't have to take anybody's word for it, just drive to the edge of Albemarle County like you're going to Gordonsville. Continue on 15 and you can see what's actually there, which will be similar to this, and make your own determination as to what the impact of the future.
I do think that the work that PEC has done with their, they can create a simulation. I went to a seminar where they showed this,
Hmm.
for the scenic Virginia seminar. And those simulations are very effective for giving an idea of what I mean, the picture that we just showed, I couldn't even see the thing.
Almost intentionally.
But I do think that the BEC tool has been great for showing you what something really is going to look like based on what the specs are that they give you the input. So if we have any interest in showing that sort of thing, I think that's good technology. They completed the line, Gordonsville North is what you're saying.
Yeah, and 115.
Where does it go relative? Well,
So here is,
It is further west, but there's a peak of plant
Just Google it.
down there.
Street View.
Street gas powered peak.
So this is the Lawson property.
It's just Google.
You trying to get an action that will get them back on longer so you can fight harder, or are you trying to?
We're just letting you know at this stage that we're doing the review, and the outcome of the review determines whether we need to do anything.
Well, I'm very on this. We should be looking at it from the view. Is there any, I don't want to get into weird stuff, but this is going to carry a lot more current. We'll call it. And then putting it up high. So is the radiation density
It's an interesting that the wreck and rebuild is for a 2-circuit 230 kV line. 1 circuit will remain idle. So what will initially be connected is exactly what's there. I'll be able. What's proposed at the SEC is basically single circuit 230 kV line. And they think it's something future they might activate the rest of them.
Nice.
Well, they'll have to because they'll have these expensive towers
They're gonna have a data center, so.
and reduce demand.
And then you get 11.4% rate of return for CapEx dollars.
Right. So build it now. Have people pay for it later.
Some people think so.
So we didn't find out, is there any timeline for it? Like, go back to my comment, if the authority wanted to just comment on the proposal generally as a commenting party to the impact of the proposal on our conservation interests on the property right that we hold. As we are a property owner, joining the line. Simply put. So we could comment on it. Is that timely or something that is right for us to do now? Or is that a different timeline?
It's a different SEC.
Okay. So that would be something that we would comment on when it goes through the SEC.
Unless there's some legal aspect.
Not that I know of.
Because I see us as an adjoining property.
Yeah.
So fundamental question again is if you think you can review this by July 8th and bring it back to this body for a decision on how to proceed prior to July 8th, that's fine. If you don't think that you can meet that timeline in a responsible way, then we should be requesting to the SEC that they extend the timeline.
So I think I had thought that we would review these deeds, and if we found something that we had an issue with, then we could call a special meeting, because July 8th is before the next regularly scheduled meeting, to discuss it. And if we found that we think there is no issue, then we would not need to call a meeting because there wouldn't be anything to discuss.
I mean, I would say proactive, but if you have anything that indicates that they do not have 100-foot right of way, we should intervene in some way. We should say, we should notify that.
Yeah.
Property that doesn't allow for 100-foot wide. But that would obviously depend on the research.
Is it, what was the rationale between for 100-foot right away?
Well, I'm not an electrical engineer, but with California, the wire comes down. So just in that sort of wild, big fire. And so, notion of what's an adequate right of way for tall towers has clearly changed from 1980. The 100-foot right of way, if it indeed exists, would not have been sufficient for convenience. It's right now saying it is.
Yeah.
Yeah, I'm a little surprised they're not asking for more right of way, because I thought that the old idea was if the tower falls down, you have to have that many feet to the right and that many feet to the left.
Interesting. Well, I guess they probably know that would be bigger. They're aware of the corridor that they're trying to push this through.
But I was still surprised it was not something like the ASTO standards for roads that they would run up against, and it would be considered improper for them to build a 130-foot tower on a 100-foot right of way. But
Well, is there any procedure? All that into question, let alone whether or not they.
Yeah, that will come up in expert testimony. Oh. So you feel comfortable with your
if you find an oddity, do you need a special meeting or can you just ask for the standard timeline because of an oddity having been discovered?
I think what staff will do is staff will go back and take a look at this, share the results of what we find. And if the authority chooses to call a special meeting as a response to the additional information, staff will accommodate that.
What's the latest you call a special meeting to be responsive by the 8th?
Well, again, so there needs to be at least 3 days advance notice, published notice. So, I mean, I'm comfortable that we have almost a month. So I'm comfortable that we can find the deed and get that information to you. And then again, it's up to you all whether to hold a special meeting before that.
Who's doing the deed research?
I don't know that nobody from the board has asked about this of us yet. So.
I mean, I wonder whether at some point
Sounds like Peter, we talked to your
we
representative.
shouldn't send a little guidance to the board saying, I mean, obviously Strawberry Hill is a much bigger fish than this.
Yeah.
Um,
The board has $1 million property interest.
and, if we were to formulate some, conservation minded, kind of broad brush comments to send to the board and say, we sort of hope you all think this too.
And what is the OF doing on this one? Just out of curiosity, do you know?
The
Relative to its, does it hold Strawberry
people
Hill?
who are involved in this are not me. I believe what their basic position is kind of what we've said here, that if they're doing something within their own right of way, there's not much we can do about it.
Right.
I don't think they're going to try to stop something that Dominion can probably do by right through the kind of softer conservation value type things. I think it, but as I say, I haven't been involved in discussions at all, so that's just kind of what I've gleaned, is that unless they start asking for more right of way, we don't really have much leg to stand on.
Yeah, okay, the easement on Strawberry Hill was pretty specific about protecting the view shed and the Albemarle County's natural, scenic, and historic resources, unique natural resources, wildlife habitats, open spaces. Whereas the Natural Foundation has numerous open space easement in Southwest Mountains, Monticello and Montpelier, and area possessing houses and farms with historic significance. So scenic resources is a key part of this easement.
Of all of these.
And
Well,
but this even more so than some. And so numerous clauses. So the question is back to the Board of Supervisors, if this is the document and $1 million of 2008, $1,000,003 of 2008 taxpayer dollars have been used to do this, you just analyze it, look into it, or are you going to just let it go?
Well, again, we're going to follow the board's direction. I mean, if the board directs us to take a look at Strawberry Hill, again, which is a board held easement, we'll certainly do that.
Just remind us, Bonnie, that we spent 2 hours in our previous meeting talking about whether a dock was an impervious surface and what runoff was. We're talking about pretty significant change in one of the most protected areas in the state of Virginia. I think it will have profound effects on conservation easements. Perhaps. Thank you.
I mean, did I get the message here that this is not the time for us to put forward the kind of comment that we were just talking about scenic and historic resources, that this is only a timeline question?
It's like, I think first most immediate question is whether there needs to be a request for a meeting and a new timeline from the SEC. This is an unusual. What I'm told by our attorneys, this is an unusual shortening of a traditional process. And so the question is if that is sufficient time, then the second part is, okay, in an SEC hearing, they are required by statute to look at all the broad consequences of what's being proposed. That's when you could bring in expert testimony, you could bring in planning trusts that hold easements, you could do these things, and the SEC will ultimately determine whether they could go forward or not.
Yeah, and I would think that we should definitely be commenting at that time about the impact that it would have on the scenic resources that we're trying.
That line is not this.
That's in my understanding. What
I think now is timeline and it was legal.
James, what is the plan for the July meeting?
Regarding this issue or otherwise, no plans yet.
Because I'm not gonna be around.
Okay.
But you don't have any requests that you know that you'll be bringing.
Not that we know. No. That's quite typical though, but not to know a month in advance.
I personally trying to figure out what this body can do in the short term. Because long term, it's just timing thing. The short term seems to have them change, get them to change their mind to do it on a normal timeline. Or is it? I mean, the business of the right of way seems to be appropriate to address at this point.
Yeah, I'm not an attorney, and there may be different perspectives. I'm a landowner very near this, and so my perspective may not be everybody else's perspective. But the near term question is this enough time to adequately review the various aspects of this? Of course, there is a lawsuit which will be in court next week, which will be decided by a judge, and if, that could change this. And, it's you're fighting big.
Yeah.
That is everything we have for new business.
All right, old business. Do I hear a motion to adjourn? Thank you all.
Yes, stop.